Imagine you walk into a small shop in Addis Ababa, point to a loaf of bread, hand over 20 birr, and the shopkeeper hands you the bread. No papers were signed, no lawyers were called. Yet a contract has just been formed. How? The answer lies at the very heart of Ethiopian contract law: consent. Let us begin with the exact words of the law. Article 1679 of the Ethiopian Civil Code, under the heading Consent Necessary, states, "A contract shall depend on the consent of the parties who define the object of their undertakings and agree to be bound thereby." Article 1680, titled Agreement of the Parties, provides, "A contract shall be completed where the parties have expressed their agreement thereto. Reserves or restrictions intended by one party shall not affect his agreement as expressed where the other party was not informed of such reserves or restrictions." Article 1681, on the form of offer and acceptance, states, "Offer or acceptance may be made orally or in writing, or by signs normally in use, or by a conduct such that there is no doubt as to the party's agreement. The party who makes an offer may stipulate a special form of acceptance." Article 1682 declares, "Silence where an offer is made shall not amount to acceptance." Now let us break these provisions down element by element. The first and most fundamental principle is found in Article 1679. A contract depends on consent. Consent in Ethiopian law has two precise components. First, the parties must define the object of their undertakings. Second, they must agree to be bound by that object. Without both elements, no contract exists. Article 1680 takes us a step further. A contract is completed when the parties have expressed their agreement. Internal thoughts do not form contracts. Suppose a seller secretly intends not to deliver on time, but expresses agreement to deliver on Monday. The buyer is entitled to hold the seller to what was expressed. The law protects the reasonable understanding of the other party, not secret mental reservations. This is the objective theory of contract. Article 1681 governs the form of offer and acceptance. Ethiopian law is generous here. You may communicate offer or acceptance orally, in writing, by signs normally used in society, or by conduct that leaves no doubt about your agreement. Raising your hand at an auction, nodding when a vendor offers tomatoes, or taking goods to the cashier are all valid. However, the offeror may demand a specific form of acceptance. Article 1682 introduces a vital protective rule. Silence does not equal acceptance. If a merchant sends you an unsolicited offer saying, "If I do not hear from you within 7 days, you have accepted, you are not bound by your silence," this protects individuals from being trapped into contracts they never wanted. But this principle has important exceptions. Article 1683 provides the first exception. Where a party is bound by law or by a concession from public authorities to enter into contracts on pre-stipulated terms, no acceptance is required. Think of utility companies that must serve all customers. In these cases, the contract is completed simply upon receipt of the offer. Article 1684 gives the second exception, pre-existing business relations. When parties already have a contract and one offers to continue or vary it, silence may amount to acceptance, especially if the offer is made in a special document warning that silence within a reasonable time will be treated as agreement. Article 1685 addresses invoices. Particulars a party writes on an invoice do not bind the other party unless they match a prior agreement or are expressly accepted. Article 1686 deals with general terms of business, what we call standard form contracts. These standard terms only bind if the other party knew about them and accepted them, or if they were approved by public authorities. Finally, Article 1687 clarifies what is not an offer. A person who declares an intention without communicating it to the beneficiary is not making a binding offer. And critically, sending tariffs, price lists, catalogs, or displaying goods for sale to the public does not count as an offer. These are merely invitations to treat. The customer makes the offer when they bring goods to the cashier. The shopkeeper accepts when they agree to sell. Let us apply these rules. Consider Almaz, who walks into Bekele's electronics shop in Mercato. She sees a television with a price tag of 15,000 birr. Under Article 1687, that display is not an offer. Almaz approaches Bekele and says, "I will buy this television for 15,000 birr." That is the offer. Bekele nods and begins wrapping it. By his conduct under Article 1681, he has accepted. A contract is formed. Now suppose Bekele secretly intended to charge an extra 500 birr for delivery, but never mentioned it. Under Article 1682, Almaz is not bound by Bekele's hidden reservation. The agreement is as expressed. 15,000 birr for the television. Consider another scenario. Chaltu receives a letter from a magazine company saying, "We will send you our magazine every month for 200 birr. If you do not reply within 15 days, we will assume you have agreed." Under Article 1682, Chaltu's silence is not acceptance. However, if Chaltu had been a subscriber for 2 years and the company offered to renew at a slightly higher price, under Article 1684, her silence could amount to acceptance. Take a third example. Dawit runs a wholesale business. He has a long-standing supplier, Ephraim. After they verbally agree on a delivery of 100 bags of teff at 3,000 birr each, Ephraim sends an invoice that adds a 5% late payment penalty never discussed. Under Article 1685, that new term does not bind Dawit, because it was not part of the prior agreement, and Dawit never expressly accepted it. Finally, suppose Fatuma signs up for an online service that has general terms of business buried in a long document she never read. Under Article 1686, those terms do not automatically bind her unless she knew about them and accepted them, or they were officially approved. For your exam, remember these key points. First, consent is the foundation of contract under Article 1679. Always start your analysis there. Second, distinguish between the objective theory under Article 1680 and the subjective reservations of the parties. The law protects what was expressed, not what was secretly thought. Third, master the forms of acceptance under Article 1681 and remember that the offeror can dictate a specific form. Fourth, the silence rule under Article 1682 is general, but be ready to identify the 3 main exceptions: legal duty to contract under 1683, pre-existing business relations under 1684, and the offeror's express stipulation. Fifth, distinguish offers from invitations to treat under Article 1687. A common exam pitfall is treating a price tag or catalog as an offer. It is not. Sixth, invoices and general terms under Articles 1685 and 1686 only bind when there is prior agreement or actual knowledge and acceptance. Always cite the specific article number when you answer. Thank you for joining us today. Whether you are a law student preparing for your contracts exam or simply a citizen curious about the rules that govern daily transactions in Ethiopia, we hope this lesson has made these foundational provisions clearer. Please subscribe for more Ethiopian law content and keep learning.